Welcome to Quick Counsel with Kristen Lavoie and Aaron Van Kampen, where we provide you with an overview of a legal issue or share a practice tip in just a few minutes. This week, I'm going to talk to you a little bit more about the Michigan Supreme Court. You might recall that last episode, we talked about the pending issues before our Supreme Court this term and gave you an idea of some of the issues to keep an eye out for in the months ahead. This time, we're going to talk a little bit more about these justices and the fact that they have some opinions. Many of our justices have written opinions over the past year expressing interest in deciding specific issues. They're giving us some not so subtle hints about the issues they would like to see attorneys litigating in the trial court and preserving for them to consider on appeal. Often, justices' concurring and dissenting opinions are the best source of information for the kinds of issues they're most interested in hearing. And often, in these opinions over the past year, justices have lamented that an issue they're interested in isn't properly before the court because it wasn't raised in the trial court below. So, we're here today to encourage you to give our justices what they want and start litigating some of these issues in the trial court so that they can be preserved for appeal and maybe turn into some really great case law that can help us better advocate for our clients one day down the road. For a list of these issues and links to the opinions themselves, you can use this QR code. I'll show you this code again at the end of this episode so that you can pull it up then. But now I'm going to go through and highlight some of the issues you might want to keep an eye out for as you work on your cases in the year ahead. When it comes to search and seizure, Justice Kimberly Thomas, one of the newest to the court, wrote an opinion expressing an interest in providing greater clarification and guidance about the point at which a short detention or a Terry stop becomes a full-blown arrest that requires probable cause. In another opinion, Justice Welch wrote about her concerns that the long-standing precedent establishing that a drug detection dog's alert establishes probable cause for a search may no longer be good law, especially when the dog is trained to detect marijuana, a substance that is now lawful for adults 21 and over to possess in pretty large quantities here in the state of Michigan. On the front of evidence and what can and cannot be used in court, there were a number of opinions where justices expressed an interest in either re-examining an established area of the law or further exploring one where our jurisprudence isn't particularly developed. Those issues include the Watkins decision related to the admissibility of other acts evidence and some of the aspects and the factors that courts must consider under Watkins and whether our lower courts are doing it properly. Justice Thomas wrote an opinion expressing an interest in further exploring the limits on when police officers may narrate video evidence. And multiple justices wrote opinions expressing an interest in considering the reliability of certain types of scientific or technical evidence. Specifically, Justice Thomas wrote about an interest in considering the reliability of certain expert testimony about child sex abuse. And our Chief Justice, Kavanaugh, wrote about a desire to consider the reliability of tool mark and firearm evidence as a field. And so those are some issues you'll want to keep an eye out for on your cases. When it comes to trial, a number of issues are on our justices' mind, and they include what standards apply to a motion to strike for cause based on juror bias. Multiple justices wrote opinions expressing concern that the lower courts aren't properly analyzing confrontation claims, that they're often analyzing them under our state laws related to hearsay, and that might not fully capture or encompass the entirety of the accused confrontation rights. When it comes to courtroom closures, we had an opinion expressing concern that the lower courts aren't necessarily following the proper standards and considering whether there are less extreme measures that can be taken whenever there is the sort of concern that might trigger a closure. And there are also opinions from two opinions from Justice Thomas related to shackling or the appearance of the accused or defense witnesses at trial, and whether courts are properly following the controlling standards and whether Michigan's case law is actually sufficiently developed. She expressed concern in both opinions that Michigan's case law hasn't sufficiently incorporated the standards established by the United States Supreme Court, or standards that other states have gone and adopted since. When it comes to sentencing, Justice Bolden expressed an interest in further exploring when it is appropriate, or whether it's appropriate at all, to score offense variable 14 for a leadership role in a situation where the defendant is the only person who was ever charged or convicted of any crime. In addition, Justice Welch has written a number of opinions expressing concerns that the lower courts need better guidance, more specific guidance about how to determine whether a sentence is proportionate as required by our state constitution. And she also expressed an interest in reconsidering whether consecutive sentences need to be considered in the aggregate when it comes to assessing proportionality, or whether they should only be assessed individually, which is the current rule under People v. Miles. So, what do you do with these issues now that you're aware of them? Well, you want to keep an extra eye out for them in your cases. And if they come up, you want to think about making an objection or maybe even filing a motion, including some briefing. And the best part is because you have these opinions from the justices telling you their concerns about these issues, you can go and read those opinions and incorporate their concerns into your arguments. I like to think about this sort of litigation as planting seeds, right? If we plant the seeds in enough of these cases, sure, you're going to win some of these cases. Some of these cases aren't ever going to go up on appeal. But if you plant the seeds in enough cases, eventually, maybe it will grow, it will rise up in the appellate courts, and we will get that beautiful flower, that wonderful decision that makes it that much easier for us in the future to better advocate for justice for our clients. As I promised, here is that QR code where you can pull up a list of these opinions that I've covered here and a few more. In addition to a list of the opinions, you'll find links to the opinions themselves, and hopefully that will make it much easier to keep these issues in mind and start planting those seeds for the future. This has been another episode of Quick Counsel. Thank you for joining me. If you're interested in more, or if you would like to find CLE eligible training videos, please check out our website at WayneCountyDefenderTraining.com, or you can use this QR code on your screen and pull it up that way. See you next time.